If a contract of an employee gets over in the midst of her maternity leave, will she still get the benefit under the Maternity Benefit Act? Well, to understand the legal position for this question, we have to go through the landmark judgment given by the Honorable Supreme Court of India on the 17th day of August 2023 in the case of Dr. Kavita Yadav. Hey guys, this is Ganesh Pujari and welcome to one more discussion on a landmark judgment. What are we waiting for? Let's get into the first slide. Here is what happened in the case of Dr. Kavita Yadav versus the Secretary, Ministry of Health and Family Welfare Department and others. Let us discuss this case law in four major parts, which are the appellant, the employment contract or the contract employment, the maternity case and the judgment. The first three are discussed here in this slide and the last one is discussed in my next slide. The first part, that is, who was the appellant? Dr. Kavita Yadav was a doctor specializing in studying medical conditions using various bodily substances like tissue, blood and urine. She got a job as a senior resident in pathology department at Janakpuri Super Speciality Hospital, which is a part of the Delhi government. The second part, the employment contract or contract employment. When Dr. Kavita started working there on 12th June 2014, her appointment was meant to be temporary for 1 year. However, her contract could be extended every year for a maximum of 3 years. Her services were extended twice, first on 12th June 2015 and then on 12th June 2016. The last extension was from 12th June 2016 to 11th June 2017. The third part of the case, that is the maternity case. Dr. Kavita applied for maternity benefits on 24th May 2017, starting her maternity leave from 1st June 2017. According to the Maternity Benefit Act 1961, she was entitled to maternity benefits. However, her employer informed her that she could only get maternity benefits for 11 days because her contract was supposed to end on 11th June 2017. That means from 1st June to 11th June 2017, she will get maternity benefit and they will not extend it any further based on their rules. The last and very important part of this legal tussle and the judgment is discussed in my next slide. Dr. Kavita tried to challenge this decision first in the Central Administrative Tribunal and then in the Delhi High Court. However, both of these attempts were unsuccessful with the same reasoning that her contract had ended. The Supreme Court in its judgment disagreed with these previous decisions. The case at hand was heard by a distinguished three-judge bench comprising Justice Aniruddha Bose, Sanjay Bangar and S.V.N. Bhatti, and they believed that once Dr. Kavita met the criteria for maternity benefit according to the Maternity Benefit Act of 1961, she should get the full benefits even if this period extended beyond her contract duration. They argued that trying to enforce the contract duration during this period would be considered as discharge and go against the law. The Supreme Court has made it abundantly clear that maternity benefits must be granted even if the period of benefits overshoots the terms of contractual employment. This ruling is based on Section 5 and Section 8 of the Maternity Benefits Act 1961. Supreme Court in its ruling on Thursday, the 17th day of August 2023, declared that maternity benefits are not bound by the term of contractual employment. The Apex Court emphasized that employers must adhere to Section 5 and Section 8 of Maternity Benefit Act 1961, which obligates them to extend these benefits to eligible employees. This ruling underscores the importance of upholding the rights of pregnant employees and ensuring they receive the benefits they are entitled to. This judgment carries profound implications for women in the workforce and sets a precedent for the upholding maternity rights. It reinforces the idea that no contractual agreement should stand in the way of providing essential maternity benefits to eligible employees. So, they overturned the previous judgments and directed Dr. Kavita's employer to provide her with maternity benefits as per the Maternity Benefit Act within 3 months of their judgment.
Don't ever stop attempting, because if one door closes, another surely opens, provided we give our best shot. With that, I'm concluding this session. Please subscribe our channel. Please like, share and comment our videos. Thank you. Bye-bye.